Next page, Chapter 17, 17.1 Definition of partnership. Legal relationship created by contract between two or more persons. Partners contribute to the business, which is carried out for joint benefit and profit-making. Entities involved can include natural persons and juristic entities, for example, companies, close corporations. Can be formed between companies for specific tasks, joint venture. No separate legal personality. Partners are personally accountable for partnership activities. Case, Mora no via coup, companies exist under legislation, whereas partnerships depend on agreements between partners. Lack of continuity, partnership dissolves if a partner withdraws, voluntarily or by death. Next page. 17.2 Partnerships and the Companies Act, 2008. Companies Act, 2008 does not define or regulate partnerships but allows for the formation of a personal liability company. Definition of juristic person, S1, does not include partnerships. Application of partnership law in corporate winding up, C17 10.1. Personal liability companies, directors, past and present, are jointly and severally liable for debts incurred during their tenure. Sometimes referred to as an incorporated partnership. Must have incorporated in their name. Commonly used by professionals, for example, attorneys, seeking perpetual succession while retaining personal liability. The Warner Memorandum of Incorporation must state that directors are personally liable for contractual, not delictual, obligations. 17.3 Types of partnership. 2 primary classifications. 1. Universal partnerships versus particular partnerships. 2. Ordinary partnerships versus extraordinary partnerships. 17.3.1 Universal and particular partnerships. Universal partnerships, partners contribute all property, or all profits for broad purposes. Usually open-ended, with shared profits from various enterprises. 2 types. 1. Partnership universorum bonorum, involves all present and future property, common in marriage. 2. Commercial universal partnership, partners share all acquisitions made during the partnership. Case, Isaacs v. Isaacs, defined as a partnership where all property is shared between parties. Particular partnerships, partners contribute resources for a specific venture. Temporary and focused, with profit sharing limited to that venture. Case, Bester v. Van Niekerk, partnership applies only to a particular transaction, for example, joint legal case, specific trade. Case law on universal partnerships. Schroepfer v. Ponlat. Issue, whether a universal partnership existed between cohabiting parties. Held, a tacit universal partnership can exist between unmarried cohabitants if they pool resources. Court's reasoning, similar to marriage in community of property. A partnership can exist even without marriage, if there is an agreement, express or tacit, to share property. Adcock v. Adcock. Issue, plaintiff claimed a universal partnership between herself, her husband, and a trust. Key findings, universal partnership can exist without an express agreement, can be tacit. Test, the conduct of the parties must indicate a partnership more likely than not. Trusts are generally not considered partners unless trustees intended to bind the trust. Claim dismissed, the trust was structured to keep assets within the family, not as a partnership asset. Mulman v. Mulman confirmed that a universal partnership can exist between spouses in commercial ventures, even if married out of community of property. This summary maintains detail while improving clarity and structure. Let me know if you need further refinements. Next page. Here are your detailed study notes. 17.2 Partnerships and the Companies Act, 2008. Companies Act, 2008 does not define or regulate partnerships. Definition of juristic person in S1 excludes partnerships. Partnership principles may apply when winding up certain companies, C17, 10.1. Personal liability companies incorporated. Directors, past and present, are jointly and severally liable for debts incurred during their tenure. often described as incorporated partnerships. Name must end with incorporated or incorporated. Common for professionals, for example, attorneys seeking perpetual succession. Memorandum of Incorporation, MOI, must expressly state directors' personal liability for contractual, not delictual, obligations. _ 17.3 Types of Partnership. Categorization of partnerships. 1. Universal versus particular partnerships. 2. Ordinary versus extraordinary partnerships. _ 17.3.1 Universal and particular partnerships. Universal partnership. Partners contribute all property or all profits for an open-ended period. Profits are shared from all enterprises. 2 types. 1. Partnership universorum bonorum. Common in marriage, in or out of community of property. Includes all present and future assets. 2. Universal partnership in commercial settings. Covers all acquisitions during the relationship from any business activity. Isaacs v. Isaacs defined partnership universorum bonorum as a contract putting all property into common ownership. Sherpa v. Ponat, case study. A domestic partnership exists when cohabitees agree to pool resources. Comparable to marriage in community of property. Court ruled that the plaintiff had a right to partnership assets despite not being legally married. Adcock v. Adcock, case study. Plaintiff argued for a universal partnership between herself, husband, and a trust. Court findings. Universal partnership does not require a written agreement. Tacit agreements can be inferred from conduct. A trust cannot be a partner unless trustees explicitly intend to bind it. Outcome: plaintiff's claim was dismissed. _ 17.3.2 Ordinary and extraordinary partnerships. Ordinary partnership. Joint and several liability for all debts of the partnership. Extraordinary partnerships. Liability of certain partners is limited. 3 types. 1. Anonymous partnership. 2. Partnership en commandite. 3. Special partnership, under repealed laws. 17.3.2 Anonymous partnership. Business conducted in one partner's name. Anonymous partners remain undisclosed to the public. Anonymous partners are not liable to third parties. Liability only extends to other partners as per agreement. 17.3.2 Partnership en commandite. Similar to an anonymous partnership, but with one key distinction. Partner en commandite contributes a fixed sum. Their liability is limited to their agreed capital contribution. If no profits, they only lose their contribution. 17.3.2 Special partnership. Existed under now repealed laws. Structure. General partners, jointly and severally liable, manage the business. Special partners contribute a fixed cash amount, not personally liable beyond their contribution. Limited liability depends on anonymity and non-involvement in transactions. _ 17.4 Essentials of partnership. Defined in Joubert v. Tarry and Company. 1. Contribution. Each partner must contribute something, money, labor, or skill. 2. Joint benefit. The business must benefit all partners. 3. Profit motive. The primary objective must be profit. 4. Legitimate contract. Agreement must be valid under law. Adcock v. Adcock reaffirmed these principles. Partnerships can be written, verbal, or implied. If any essential element is missing, no partnership exists. Key considerations for a written partnership agreement. Partnership name. Business purpose. Roles of partners, active versus passive. Profit-sharing ratios. Loss-sharing arrangements. Authority to contract on behalf of the partnership. Other unique specifications. If essentials are present, the court will recognize the relationship as a partnership, regardless of what the parties call it, for example, joint venture. _ These study notes summarize the key legal principles, cases, and legislation governing partnerships. Let me know if you need further refinements. Next. Page 17.4 Essentials of Partnership, Continued 17.4.1 Contribution by Partners. Each partner must contribute something of commercial value. Contributions may include money or property, for example, shares in movable assets, skill, knowledge, expertise, or labor, contacts, experience, or equivalents. Contribution need not be precisely quantifiable in monetary terms. 17.4. Do business should be for joint benefit of the parties. Definition of business: any activity occupying a person's time, labor, or attention for profit. Partnerships can exist for single transactions, provided other requirements are met. Joint benefit requirement. No partner should claim individual benefit without sharing profits/losses. South African law does not allow partnerships where one partner receives all benefits while others incur all losses. 17.4.3 Business should be carried on to make profit. Ally v. Dynath. A partnership must aim for profit or material gain. Saving costs or accumulating a joint estate is sufficient. Non-commercial goals, for example, welfare, charities, do not qualify. Butters v. Nkora. A partnership may extend beyond purely commercial enterprises. 17.4.4 Legitimate contract. A partnership is formed through a valid agreement. Essentials must be met, and there must be a clear intention to create a partnership. Pezzato v. Dreyer. Courts consider agreement substance, circumstances, and party conduct. Self-identification as partners is important but not decisive. Profit sharing and contributions serve as strong evidence of partnership. Burden of proof: the party alleging a partnership must prove it. Case studies on partnership existence. Harrington v. Fester. No written agreement. Correspondence only showed intent to enter a partnership. One party treated the other as an employee, contradicting a partnership claim. Lack of partnership bank account was also a factor. Pezzato v. Dreyer. A handshake agreement was alleged. Court held that a valid partnership existed as parties agreed on contributions. Exact roles were not required for validity. 17.4.5 Other legal formalities. A partnership must comply with the law, i.e., no illegal business activities, no formalities required. Agreements may be written, oral, or implied by conduct. Parties may impose formalities. If partners agree on a written contract requirement, the partnership only exists once signed. These notes summarize the essentials of partnerships, including legal requirements, key case law, and formalities. Let me know if you need further refinements. Next. Page 17.5 Legal nature of partnership. Partnerships do not have separate legal personality, unlike companies. South African law follows the aggregate theory. Partnership equals collection of individual partners. Partners own the property in undivided shares. A change in partners dissolves the partnership. Entity theory, not applied in SA, treats a partnership as separate from its members. Judicial inconsistency. Some cases suggest partnerships have quasi-personality in commercial contexts. Case study: Partnerships and Tax Law. Sachs v. Commissioner for Inland Revenue. Income belongs to partners in common, not a separate entity. Tax obligation arises when profits are allocated, not when income accrues. Section 24H of the Income Tax Act. Each partner is considered to be carrying on the business of the partnership. Prevents delayed taxation by holding income at the partnership level. 17.5.1 Insolvency exception to partnership. Lack of legal personality. Section 13(1) of the Insolvency Act. Sequestration of a partnership estate equals simultaneous sequestration of partners' personal estates. Creditors of the partnership can claim only against the partnership estate. Creditors of individual partners claim against personal estates. Any remaining balance in an estate can be transferred to the other where necessary. Case study: Insolvency exception. Michael Ono v. Premier Milling Company Limited. The Insolvency Act treats the partnership as a separate estate. Partnership creditors cannot claim against individual partners' estates in the first instance. Courts limit this exception strictly to insolvency matters. _ 17.5.2 Litigation exception to partnership lack of legal personality. General rule. All partners must be cited in litigation involving the partnership. Before Rule 14 of the High Court rules, a partnership could not sue or be sued in its own name. Rule 14, High Court, and Rule 54, Magistrates' Court, now allows partnerships to be sued in their own name. Still not considered a separate legal person, but treated as one for litigation purposes. _ These notes summarize the legal nature of partnerships, including theories, key case law, and exceptions in insolvency and litigation. Let me know if you need any refinements. Next. Page 17.6 Relationship between partners. Partnerships are based on utmost good faith, ubereni fidei. Partners owe fiduciary duties to each other. Good faith is essential in contractual interpretation, but does not exist in degrees. The partnership agreement governs relationships, but good faith guides its interpretation. Rights of partners. Share in profits. Participate in management. Right to compensation. Inspect partnership books. Receive assets upon dissolution. Duties of partners. Contribute to the partnership. Share in losses. Exercise care and skill. Provide full disclosure and account for transactions. _ Duties arising from good faith. 1. Duty to accept and fulfill partnership obligations. Purdon v. Miller, a partner who fails to uphold obligations cannot demand equal treatment. 2. Duty to acquire benefits for the partnership. A partner must not retain benefits related to the partnership's business. Matson v. Yanakis. A profit-making transaction must fall within the partnership's scope to belong to the partnership. Example, a plumber using partnership assets to write a novel does not make the novel a partnership asset. Partners may not compete with the partnership. Any profits from competing businesses must be shared with the partnership. 3. Duty to avoid conflicts of interest. A partner must not prioritize personal interests over partnership interests. If a partner receives a payment from a debtor also owing the partnership, the partner must account for it. Case study, De Jager v. Oliphants Tinby Syndicate. A partner secretly acquired an option on land containing tin. The court ruled he had to transfer the benefit to the partnership. Key legal principle. No partner may personally acquire a benefit that should belong to the partnership. 4. Duty of full disclosure. Partners must disclose all relevant information affecting the partnership. Concealing information that could influence partnership decisions breaches fiduciary duty. This reinforces the duty of utmost good faith in all transactions. _ These notes cover partnership relationships, rights, duties, fiduciary obligations, and key case law. Let me know if you need further refinements. Next. Page 17.7 Authority of partners to contract with third parties. South African law follows the aggregate theory of partnership, meaning a partner acts as a principal regarding themselves. A partner acts as an agent representing other partners. Actions bind all partners if performed within the scope of authority. Case study, Pooley v. Driver. Jessel Mr. A partner is an agent for others only because the law does not recognize the firm as a separate entity. Partners act as both principal and agent in transactions. _ 17.8 Authority of a partner to bind the partnership. Two forms of authority. 1. Actual authority. 2. Ostensible apparent authority. 1. Actual authority. Express, given explicitly by agreement. Even if the transaction is outside usual business, the partnership is bound. Implied, based on customary dealings of the partner. Example, if a partner manages the business, they have general authority for ordinary transactions. Unless limited by the partnership agreement, a partner has implied authority to perform necessary acts for the business. Dispute over whether an act falls within the partnership's business. The test: if the transaction falls outside the scope of business, the partner has exceeded their authority. The burden of proof is on the third party seeking to enforce the contract. Case study: Goodricks v. Hall. A restaurant partnership, A and B hired an attorney for a liquor license. Court ruling: no agreement restricted B's authority. Applying for a liquor license was in the partnership's business scope. B's action was valid under implied authority. Implied authority can be modified by express agreement. 2. Ostensible authority exists when a partner appears to third parties to have authority. Estoppel applies: partners cannot deny authority if they allowed the appearance. Case study: Levin v. Barclays Bank DCO. Two people opened and operated a bank account as a partnership. Court ruling: their conduct implied partnership existence, making them liable. If a partnership allows a non-partner to act as a partner, it may be bound. Key rule: even if no real authority exists, if a partner appears authorized, the partnership is bound. The third party can rely on the appearance of authority unless aware of restrictions. Page 17.9 Personal liability of a partner. Partners are jointly and severally liable for partnership debts. Case: Deldenhuis v. East and West Investments, Proprietary, Limited. The court held that both partners were jointly and severally liable for unpaid rent. A creditor may sue both partners for the full amount during the partnership's existence. Creditors must sue all partners together, not individually. Exception: upon dissolution, creditors can claim against individual partners. Insolvency of the partnership. Section 13(1) of the Insolvency Act. If the partnership is sequestrated, each partner's personal estate is also sequestrated. Creditors first claim against partnership assets, then individual partners' assets, after satisfying personal creditors. 17.10 Dissolution of partnerships. A partnership may be dissolved in various ways. 1. Effluxion of time. The partnership ends after a pre-agreed period. 2. Completion of undertaking. The partnership dissolves once the agreed business is completed. 3. Mutual agreement. Partners may mutually decide to dissolve the partnership. 4. Change in membership. Retirement, death, or admission of a new partner terminates the partnership. The remaining partners may agree to continue, forming a new partnership. Creditors are not obligated to accept new partners as debtors. Death of a partner. The partnership dissolves unless the agreement provides for continuity. The estate of the deceased may continue the business only if authorized by will. 5. Insolvency of the partnership or a partner. The partnership dissolves if either the partnership or a partner is declared insolvent. 6. Notice of dissolution. A partner may give notice to dissolve the partnership. The notice must be in good faith and given within a reasonable time. 7. War, alien enemies. If partners become enemy nationals after war breaks out, the partnership dissolves. 8. Court order for good cause. A court may order dissolution if a partner is absent for a prolonged period. A partner is incapacitated due to illness. There is an irretrievable breakdown in relations. A partner is persistently negligent. Post-dissolution rules. A proper accounting must be completed before distributing assets. Creditors may sue individual partners jointly and severally. Partners lose authority to bind the partnership post-dissolution. One partner may have implied authority for winding up the business. Each partner has the right to demand an account from co-partners. These notes summarize partner liability, partnership insolvency, and dissolution methods. Let me know if you need modifications. Next. Page 17, 10.1 Winding up of companies, and the law relating to partnerships. Section 81 of the Companies Act, 2008. A court may order the winding up of a solvent company, if it is just and equitable to do so, S. 81 1d, 3. Case Thundercats Investments 92, Proprietary, Limited v. Jane Economic Prospecting and Investment, Proprietary, Limited. A company was liquidated due to a breakdown in shareholder relations. The court found that the company functioned like a partnership. Each shareholder had equal management rights and restricted share disposal. The irretrievable breakdown in relationships made the company unworkable. Supreme Court of Appeal upheld liquidation as the only solution. Case Muller v. Lily Valley, Proprietary, Limited. Applicant sought liquidation under S. 81 1d, 3, due to a shareholder dispute. The court held that the just and equitable test is based on broad legal principles. Dissolution of a partnership-like company could justify liquidation. However, the applicant failed to prove a justifiable lack of confidence in management. Court ruled winding up was not justified. _ 17(10) to dissolution of a partnership with the trust as a partner. Trustees may enter partnerships. This can be done in writing, verbally, or by conduct. Risk: trust assets could be affected if the partnership fails and has unpaid debts. Legal implications: no separate legal personality partners are co-owners of partnership assets. Joint and several liability trustees could be liable for partnership debts. Insolvency and Section 13(1) of the Insolvency Act. If the partnership is sequestrated, the personal estates of all partners, including a trust, will also be sequestrated. Case Belden Hoyce v. East and West Investments, Proprietary, Limited. Partners were held jointly and severally liable for a disputed debt. Creditors could sue all partners and claim from individual assets post-dissolution. Key risk for trustees: entering a partnership exposes trust assets to creditors. Trustees should carefully consider the implications before entering a partnership. _ These notes provide a concise yet detailed summary of the winding up of companies, dissolution of partnerships, and trustee liability. Let me know if you need further refinement. Next page. Chapter 18, Trusts in Business and Law. 18.1 Meaning and uses of a trust. Purpose: used in estate and financial planning, asset protection and business/trading. Can own assets while a company/close corporation conducts business. If the business fails, trust assets may be protected from creditors. Flexible and requires less formality compared to companies or close corporations. Key characteristics: 1. Founder, settle, creates the trust. 2. Trustees, manages assets on behalf of beneficiaries. 3. Types: inter vivos trust, created during the founder's lifetime. Testamentary trust, created upon the founder's death, will trust. 4. Beneficiaries, must exist for a trust to be valid. Parties to a trust: founder, trustees, beneficiaries. Business, trading, trusts. Engage in business or trading activities. Trust deed includes powers allowing trustees to achieve business objectives, authority to borrow/lend funds and carry on business. Beneficiaries may have rights similar to company shareholders, for example, transfer, cede, or use rights as security. _ 18.2 Trusts and the Companies Act, 2008. Trusts are not governed by the Companies Act but may interact with companies, used to hold assets that a company operates with, offer a more flexible structure compared to companies. 18.3 Trusts and close corporations. Similar to companies, trusts can hold assets while close corporations conduct business activities. Can be used to protect assets from creditors. 18.4 Business or trading, trusts. 18.4.1 Powers of trustees. Trustees may be given broad powers under the trust deed. Can include powers to manage businesses, borrow funds, and trade. 18.4.2 Rights of beneficiaries. Defined in the trust deed. May include the right to sell, cede, or use trust rights as security. 18.4.3 Separation of control from benefit. Trustees control the trust assets, while beneficiaries enjoy benefits. Separation ensures asset protection and structured wealth management. 18.4.4 Trusts and limited liability. Unlike companies, trusts do not provide limited liability by default. Trustees may be personally liable unless indemnified in the trust deed. 18.5 Parties to a trust. Founder, settlor, creates the trust. Trustees control assets for beneficiaries. Beneficiaries entitled to trust benefits. 18.6 Trust deed, trust instrument, the legal document outlining the trust's purpose, structure and powers. Determines trustee powers and beneficiary rights. 18.7 Types of trusts. 18.7.1 Inter vivos trusts versus testamentary trusts. Inter vivos trust, created during the founder's lifetime. Testamentary trust, created upon the founder's death, in a will. 18.7.2 Family trusts versus business trusts. Family trusts, used for wealth protection and estate planning. Business trusts, used for trading and asset protection. 18.7.3 Other trusts. Ordinary trust, trustees have ownership and control of assets, non-beneficial. Bewind trust, beneficiaries own the assets, but trustees control them. 18.8 Legal nature of trusts. Governed by Trust Property Control Act. Common law. Less regulated than Companies, Trust Act 27 sections versus Companies Act, 225 sections. Trust Property Control Act definition. Contract-based arrangement transferring ownership of assets. Trustees administer assets for the benefit of beneficiaries. 18.9 Consequences of forming a valid trust. Assets separated from personal estates. Trust property is not part of a trustee's personal estate, except when they are also a beneficiary. Used for asset protection, business structuring, and estate planning. 18.10 How to form a valid trust. Must have a trust deed, a founder, trustees and beneficiaries, a lawful purpose. 18.11 Authorization of trustees. Trustees must be authorized to act on behalf of the trust, subject to fiduciary duties and legal responsibilities. 18.12 Duties of trustees. Act in good faith and in the best interests of beneficiaries. Manage trust assets per the trust deed. Avoid conflicts of interest. 18.13 Rights of beneficiaries. Can be fixed or discretionary depending on the trust deed. May include rights to income or capital from the trust, rights to transfer or cede trust benefits. These notes provide a structured and detailed summary of the key concepts related to trusts in business and law. Let me know if you need any modifications. Next page. Here's a detailed summary of the provided text. Chapter 18, Trusts in Business and Corporate Law. 18.1 Meaning and uses of a trust. A trust is a legal relationship created in a trust deed, trust instrument, used for estate planning, asset protection, and business purposes. A trust can own business assets and lease them to a company or close corporation, protecting assets from business creditors. Key characteristics. Created by a founder, donor/settlor. Founder places assets under the control of a trustee. Can be created during a founder's lifetime, inter vivos trust, or upon death, testamentary trust. Must have at least one beneficiary. Main parties to a trust. Founder. Trustees. Beneficiaries. Business or trading, trusts. Conduct business activities through trustees. Trust deed includes business-related clauses. Why trustee powers? Borrowing and lending powers. Beneficiaries have similar rights to company shareholders. Regulation. Trust Property Control Act primarily governs trusts. Unlike companies and close corporations, trusts have fewer statutory requirements. Defined as an arrangement where ownership of assets is transferred to trustees to manage for beneficiaries. Types of trusts. Inter vivos trust, created during the founder's lifetime. Testamentary, will, trust, created upon the founder's death. Ordinary trust, trustees have ownership and control. Non-beneficial. Bewind trust, beneficiaries own assets, but trustees control them. Key case, Section 12 of the Trust Property Control Act states that trust property does not form part of a trustee's personal estate unless they are also a beneficiary. 18.2 Trusts and the Companies Act, 2008. Legal status of trusts. A trust is a juristic person under the Companies Act, 2008. Previously, under the Companies Act, 1973, trustees, not the trust, had to be listed as shareholders. Key case, Blue Square Advisory Services, Proprietary, Limited v. Mandingown. Under the 1973 Act, a trust was not a person and could not hold shares. Trustees had to be listed as shareholders for legal validity. The resolution to remove directors failed because a trustee not listed as a shareholder voted. Companies Act, 2008 implications. A trust, as a juristic person, can be listed as a shareholder. Section 52 requires companies to record the trust's name in the securities register. Section 45. If shares are issued for future services or delayed payment, they must be held in trust until conditions are met. Ensures compliance with share issuance agreements. 18.3 Trusts and close corporations. Membership restrictions. A close corporation, CC, generally only allows natural persons as members. Companies and CCs cannot be members. A trustee of a trust may be a CC member, provided no juristic person is a trust beneficiary. The CC is not bound by the trust deed. Beneficiaries have no rights against the CC, only against the trustees. Membership ceases if the total number of trust beneficiaries and CC members exceeds 10. Once membership ceases, the trust cannot rejoin the CC. This summary maintains the key legal principles, case law, and statutory references while reducing complexity. Let me know if you need more detail on any section. Next page. 18.2 Trusts and the Companies Act, 2008. Definition of person and juristic person, S1 of the Companies Act, 2008. A trust is recognized as a juristic person under the Act. Normally, a trust is only a relationship or arrangement and not a legal person unless specified by legislation. Other statutes recognizing trusts as legal persons. Income Tax Act. Value Added Tax Act. Trust as shareholder. Under the Companies Act, 1973, trustees were reflected as shareholders in a representative capacity. Under the Companies Act, 2008, a trust itself is recognized as a shareholder. Case study, Blue Square Advisory Services, Proprietary, Limited v. Mandingown. Issue validity of a shareholders' resolution to remove directors under the Companies Act, 1973. Problem: the share register reflected a family trust as shareholder, but a trust is not a legal person under the 1973 Act. Court ruling: a trust is a legal relationship, not a person. Trustees should have been named as shareholders in the register. The resolution removing directors was invalid as it was not passed by a legal shareholder. Section 52 of the Companies Act, 2008. Requires a company to record names and addresses of persons to whom securities are issued, the number of securities issued. Since a trust is recognized as a person under the 2008 Act, its name, and possibly the master's reference number, must be entered in the securities register. Section 45 of the Companies Act, 2008, issue of shares in trust. If shares are issued in exchange for future consideration, for example, future services or payment, shares must be issued immediately. Shares must be held in trust until the subscribing party fulfills their obligations. 18.3 Trusts and close corporations. General membership rules. Only natural persons can be members of a close corporation. Juristic persons, including companies and other close corporations, cannot hold a member's interest. Amendment to the Close Corporations Act, 2005. A trustee of a trust may be a member of a close corporation. Conditions. No juristic person can be a beneficiary of the trust. The close corporation is not bound by clauses in the trust deed. The number of trust beneficiaries entitled to benefits, plus the number of corporation members, must not exceed 10. If this condition is breached, the trustee's membership ceases permanently. 18.4 Business or trading trusts. Definition. An ordinary trust where trustees are empowered to trade, incur debts, and conduct business. Unlike non-trading trusts, where trustees cannot expose trust assets to risk. Key features. Beneficiaries can sell their interest in the trust, similar to company shareholders. Unlike passive estate planning trusts, business trusts engage in active commercial activities. 18.4.1 Powers of trustees. Trustees in a business trust are expressly authorized to trade and carry on business, expose trust assets to business risks. ISAC Family Trust v. Soni. Common law, trustees cannot expose trust assets to business risks. Exception, if the trust deed authorizes trading, trustees may assume business risks. Example. Entrepreneurs can form a trust, develop and trade property instead of using a company or close corporation. Creditors can only claim against trust assets, not personal assets of trustees/beneficiaries, unless personally guaranteed. 18.4. Two rights of beneficiaries. Beneficiaries may sell, cede, or transfer their interests, like shareholders in a company. Be issued a certificate of interest detailing their trust rights. Limited liability for beneficiaries. Beneficiaries are not personally liable for business risks. Trustees can be personally liable for reckless management. 18.4.3 Separation of control and benefit. Land and Agricultural Bank of South Africa v. Parker. Business trusts are permissible, but must maintain a separation between trustees, who control and own trust assets, beneficiaries who enjoy trust benefits. Courts and the Master of the High Court emphasize trustee independence in family business trusts. Chief Master's Directive on Family Business Trusts. A trust is a family business trust if 1. Trustees contract with third parties, creating trust creditors. 2. Trustees are also beneficiaries. 3. Beneficiaries are all related. The master may require appointment of an independent trustee, trustees to provide security, financial statements to be audited. Independent trustee definition. Not a beneficiary, not related to any trustee or beneficiary. 18.4.4 Trusts and limited liability. Trading trusts provide limited liability, similar to companies, without the formalities of a corporate structure. Risk, trust may be deemed a partnership. If trustees and beneficiaries lack separation, the trust may be classified as a partnership. To avoid this, ensure trustees are independent of beneficiaries. Avoid structuring the trust so that beneficiaries appear to own trust property. Case study, Kabola no v Ralitabo no. A trust was formed to acquire land for farming. Issues. No named beneficiaries. No trustee meetings held. Court ruling. The trust was a simulated partnership rather than a valid trust. Trustees were treated as partners, liable for debts. Next page. Study notes, business or trading, trusts and related concepts. 18.4 Business or trading, trusts. A business trust functions like an ordinary trust but allows trustees to trade, incur debts, and operate a business. Unlike passive trusts, business trusts are not solely for estate duty planning or asset protection. Beneficiaries can sell their interests, similar to shareholders in a company. 18.4.1 Powers of trustees. Trustees in a standard trust cannot expose trust assets to risk, but a business trust deed grants them authority to trade. Trustees manage business operations, and profits accrue to the trust. Creditors can claim against trust assets but not against trustees or beneficiaries unless they have personally guaranteed debts. Case: ISAC Family Trust v. Sony. Trustees cannot expose trust assets to business risks unless the trust deed expressly allows it. 18.4.2 Rights of beneficiaries. Business trust beneficiaries may sell, cede, or transfer their interests, similar to company shareholders. Trusts can be structured to resemble companies, granting trustees director-like powers and beneficiaries shareholder-like rights. Beneficiaries typically enjoy limited liability, but trustees remain personally liable for reckless decisions. 18.4.3 Separation of control from benefit. Case: Land and Agricultural Bank of South Africa v. Parker. Trust law requires separation between trustees, control/ownership, and beneficiaries, enjoyment of assets. No legal requirement for trustee independence, but the master may insist on appointing an independent trustee for family business trusts. Chief Master's directive defines a family business trust as one where 1. Trustees contract with third parties, creating creditors. 2. Trustees are also beneficiaries. 3. Beneficiaries are related to one another. Master may require an independent trustee, trustee security, or audited financials. 18.4.4 Trusts and limited liability. Trustees can borrow money on behalf of the trust, with creditors limited to claims against trust property. Business trusts provide limited liability without the complexities of a company or close corporation. However, if a trust resembles a partnership, for example, trustees and beneficiaries are the same, courts may treat it as such. Case: Kabolano v. Ralitabo. Court ruled a trust to be a simulated partnership due to lack of clear beneficiaries, trustee contributions, and absence of trustee meetings. 18.5 Parties to a trust. 1. Founder, settle/donor, establishes the trust. 2. Trustees, manage and control trust assets, appointed by the master if absent. 3. Beneficiaries, have rights per the trust deed. A trust must have at least one beneficiary. 18.6 The trust deed. A trust is created via a trust deed, also called a deed of trust or trust instrument. Unlike companies, which are statutory creations, trusts are established through legal documents. Case: Land and Agricultural Bank of South Africa v. Parker. The trust deed serves as the trust's constitutive charter. 18.7 Types of trusts. 18.7.1 Inter vivos versus testamentary trusts. Inter vivos trusts, created during the founder's lifetime, for example, business/trading trusts, estate planning trusts. Testamentary trusts, created upon the founder's death via a will. 18.7.2 Family trusts versus business trusts. Business trusts, trustees have broad business powers, beneficiaries may transfer their interests. Public trading trusts, open to the public in exchange for financial contributions. Private trading trusts, established by businesspersons for investment purposes. Family trusts, focus on asset preservation for future generations. Limited trustee powers, non-transferable beneficiary rights. 18.7.3 Other types of trusts. Statutory trusts, created under legislation for specific purposes, for example, wildlife conservation. Court order trusts, established by court orders, for example, divorce settlements. Charitable trusts, formed to support charitable causes. International/offshore trusts, operate outside South Africa and are not under the jurisdiction of the Master of the High Court. Next page. Study notes: Legal nature, formation, and authorization of trusts. 18.8 Legal nature of trusts. A trust is a creation of document, unlike companies and close corporations, which are statutory creations. Inter vivos trusts, established via contract between the founder and trustees. Crooksno v. Watson confirmed this contractual nature. Testamentary trusts, created through a will and take effect upon the founder's death. They are not contracts but legal institutions in their own right. Formalities. Inter vivos trusts must meet contractual validity requirements. Testamentary trusts must comply with the Wills Act. 18.9 Consequences of forming a valid trust. Trustees have duties, powers, and obligations outlined in the Trust Property Control Act, Common Law, and Trust Deed. Beneficiaries' rights are determined by the trust deed and partially protected under the Trust Property Control Act. May have vested rights, discretionary rights, or a combination, for example, vested right to income but discretionary right to capital. 18.10 How to form a valid trust. A valid trust must meet these essential elements. 1. Intention. The founder must intend to create a trust, imposing obligations on trustees to manage assets for beneficiaries. 2. Lawful object. The trust's purpose must be legally valid. 3. Defined property. Trust assets must be identifiable. 4. Certainty of object. The purpose of the trust must be clear. 5. Identifiable beneficiaries. There must be named or ascertainable beneficiaries, or a clearly defined impersonal objective. 6. Appointment of trustees. At least one trustee must be appointed in the trust deed, or by the master if necessary. Trustees must have legal capacity and written authorization from the master before acting. Trust Property Control Act, S6. Case, Estate Price v. Baker and Price. A will granted a surviving spouse a usufruct to enable them to support children. Court ruled no trust was created, as there was no obligation on the spouse to use income for the children. A trust requires a legal obligation for trustees to manage assets for others. 18.11 Authorization of trustees. Trust Property Control Act, S61. A person can only act as a trustee once authorized by the master. Case, Simplex, Proprietary, Limited v. Van der Merwe NNO. Trustees signed a purchase agreement without master's authorization. Court ruled the agreement was null and void as the trustees had no authority. No ratification is possible for agreements rendered void ab initio by statutory prohibition. Case, Watt v. Plant Products BPK. Confirmed trustees cannot acquire rights or incur liabilities for a trust before authorization. Unlike the Companies Act, 2008, which allows pre-incorporation contracts under S21, the Trust Property Control Act does not permit pre-formation trustee actions. Trustee and beneficiary roles. A trustee can also be a beneficiary, but cannot manage or control trust assets as a beneficiary. Multiple trustees must act jointly. Case, Land and Agricultural Bank of South Africa v. Parker. Reaffirmed the principle of separation between control, trustee, and enjoyment, beneficiary. A sole trustee cannot also be the sole beneficiary, as this contradicts the trust concept. Next page. Study Notes, Trusts. 18.8 Legal nature of trusts. Trusts are created by a document, unlike companies or closed corporations, which are statutory creations. Two main types. Inter vivos trust, created by contract between founder and trustees, Crooksnow v. Watson. Testamentary trust, created by the last will and testament of a testator. Formalities. Testamentary trusts must comply with the Wills Act. Inter vivos trusts must meet the formalities of a valid contract. 18.9 Consequences of forming a valid trust. Trustees' obligations and powers. Duties set out in the Trust Property Control Act, Common Law, and Trust Deed. Powers determined by the Trust Deed. Beneficiaries' rights. Determined by the Trust Deed and protected under certain sections of the Trust Property Control Act. May have vested rights, discretionary rights, or a combination, for example, vested right to income, but discretionary right to capital. 18.10 Essential elements of a valid trust. Founder must intend to create a trust and impose obligations on trustees. Object must be lawful. Trust property must be clearly defined. Beneficiaries must be identifiable or, if for an impersonal object, it must be clearly defined. At least one trustee must be appointed, either in terms of the trust deed or by the master if no appointment is made. Trustees must be authorized in writing by the master before acting. Case study, Estate Price v. Baker and Price. A usufruct for a surviving spouse did not create a trust as there was no legal obligation to maintain the children. A trust must impose a legal obligation on trustees to manage assets for beneficiaries. 18.11 Authorization of trustees. A trustee must be authorized by the master under S6 of the Trust Property Control Act before acting. Case study, Simplex, Proprietary, Limited v. Van der Merwe, NNO. Acts by unauthorized trustees have no legal consequences. A purchase agreement signed by unauthorized trustees was declared null and void. Ratification of a void agreement is not possible if a statute renders it void ab initio. Watt v. C. Plant Products BPK. Trustees cannot acquire rights or incur liabilities on behalf of a trust before authorization. Key distinction. The Companies Act, 2008, S21, allows for pre-incorporation contracts, but the Trust Property Control Act does not. Separation of roles. A trustee may be a beneficiary, but must not manage trust assets in their capacity as a beneficiary. Case study, Land and Agricultural Bank of South Africa v. Parker. A sole trustee cannot be the sole beneficiary, as this negates the core trust principle of separating control from benefit. 18.12 Duties of trustees. Fiduciary duty. Trustees must act with care, diligence, and skill, S91 of the Trust Property Control Act. Any provision attempting to exempt trustees from liability for breach of trust is void, S92. Financial management obligations. Separate trust account at a banking institution. Records must be maintained to indicate trust property held. Trust accounts and investments must be identifiable. Must account to the master upon request, S16. Records must be retained for at least 5 years post-termination of the trust. Trustees must act in utmost good faith. Exercise independent discretion in trust matters. Avoid undue risk to trust assets. Invest productively. Administrators Estate Richards v. Nicol. Account to beneficiaries, Doyle v. Board of Executors. Case study, the Bantu Beneficiaries Association v. Ramaphosa. Trustees failed to account for funds and ignored the master's requests. The court ordered compliance with S19, requiring submission of records and halting use of trust funds until an audit was completed. Trustees must act within the powers granted by the trust deed, and stated powers are not inferred. 18.13 Rights of beneficiaries. A trust must have a beneficiary, or it fails. Beneficiaries must be identified or identifiable, can be existing or unborn individuals. The founder and trustees can be beneficiaries. Beneficiaries may cede their rights unless the trust deed prohibits it. Business trusts often allow beneficiaries to dispose of their rights. Next. Page. 18.12 Duties of trustees. Statutory and common law duties. Section 9(1), Trust Property Control Act. Trustees must act with care, diligence, and skill expected of a person managing another's affairs. Section 9(2), Trust Property Control Act. Any provision exempting a trustee from liability for breach of trust due to negligence is void. Trustees must open separate trust accounts at a banking institution for each trust. Keep records of trust property. Ensure trust investments/accounts are identifiable as trust property. Account to the master upon written request. Retain documents, investment, administration, distribution records, for 5 years after trust termination unless approved by the master. Comply with the trust deed and act in utmost good faith. Exercise independent discretion in trust matters. Avoid undue risk, for example, unsecured loans or below market rate loans. Invest trust property productively to generate income and capital growth. Administrators Estate Richards v. Nicol. Account to beneficiaries and maintain proper financial records. Doyle v. Board of Executors. Act within granted powers and stated powers are not inferred. Case study, the Bantu Beneficiaries Association v Ramipudu Tuno. Trustees failed to account for funds, leading to legal action. Master demanded submission of financial records under Section 16(1), Trust Property Control Act. Section 19, beneficiaries or the master may apply to court to compel a trustee to perform duties. Court ordered trustees to submit records and barred them from using trust funds until an audit was completed. Chapter 1919.1 Introduction to Financial Markets Definition and Importance. Financial markets facilitate capital raising by private and public sectors. Efficient markets exhibit timely, accurate pricing information. Liquidity, assets quickly bought/sold at stable prices, low transaction costs. Prices that adjust rapidly to new information. Types of financial markets. Primary market, initial issuance of securities, capital raising. Secondary market, buying/selling of issued securities. Regulation of financial markets. Essential for market integrity and efficiency. Stability of financial systems. Investor protection. Transparent financial services. Past financial crises. 1932 Great Depression, 2008 financial crisis, emphasize need for regulation. Stock exchanges in South Africa, as of May 2021, licensed under Financial Markets Act, FMA. 5 licensed exchanges. 1. Johannesburg Stock Exchange, JSE, largest and most established. 2. Forex Exchange. 3. Equity Express Securities Exchange, EESE. 4. ZAR-X Exchange. 5. A2X Exchange. Market share, February 2017, DEC 2020, by value traded, JSE 99.87%, ZAR-X 0.11%, A2X 0.01%, Forex 0.001%. E0.003%. By volume traded, JSE 99.54%, ZAR-X 0.43%, Forex 0.01%, E0.006%, A2X 0.01%. Key takeaway: the JSE dominates the market. Newer exchanges focus on equity trading. Regulations ensure financial market stability and transparency. These notes capture all key points while maintaining the detail and structure you prefer. Let me know if you need any refinements. Rocket emoji. Next. Page 19.2 Johannesburg Stock Exchange Limited. Established in 1887, the JSE has undergone significant evolution. Vertically and horizontally integrated exchange. Horizontal integration connects buyers and sellers in multiple financial markets, equities, financial derivatives, commodity derivatives, interest rate instruments. Vertical integration provides a full range of services for these markets: listing, trading, clearing, settlement. As a licensed exchange, the JSE is responsible for enforcing its rules and listings requirements, supervising and regulating trading members, listed companies. Understanding the JSE's current role requires knowledge of its historical development. Let me know if you need more details or edits. Rocket emoji. Next. Page 19, 2.1 History of the Johannesburg Stock Exchange. Key milestones. 1887. JSE established in response to the discovery of gold on the Witwatersrand to raise capital for mining. 1947, introduction of the Stock Exchanges Control Act, the first legislation governing stock exchanges. 1963, JSE becomes a member of the World Federation of Exchanges, WFE. 1979, Krugerrands officially listed. 1995, deregulation of the JSE allows for limited liability corporate membership, foreign membership. Establishment of the South African Institute of Stockbrokers. 1996, transition from open outcry trading floor to an automated trading system, JET system. 1997, launch of SENS, Securities Exchange News Service, for real-time company announcements. 1999 New Insider Trading Act introduced. JSE collaborates with major banks to establish Strata, an electronic settlement system for securities. 2000 Introduction of Satrix 40, the first JSE exchange-traded fund, ETF. 2001 JSE acquires Safex, South African Futures Exchange, integrating equities and derivatives trading. 2002 Completion of dematerialization of all listed securities into electronic format under Strata. Transition to London Stock Exchanges, LSE, set system for trading. Introduction of FTSE/JSE African Index Series for international visibility. 2003 Launch of ALT, a parallel market for high-growth small and medium-sized companies. 2004 Introduction of Socially Responsible Investment, SRI, Index, later replaced by the FTSE/JSE, Responsible Investment Index, 2015. 2005 JSE demutualizes and incorporates as JSE Limited. Over-the-counter, OTC, trading of JSE shares begins. 2006 JSE lists on its own main board, with regulatory oversight by the Financial Sector Conduct Authority, FSCA. 2007 Migration to LSE Trading Platform. Approval for currency derivatives trading. 2009 Launch of Africa Board for African Companies. Acquisition of Bond Exchange of Africa, BESA. 2010 South Africa ranks number 1 globally in securities market regulation by the World Economic Forum. 2012 JSE replaces its equities trading platform with Millennium IT, hosted in Johannesburg. Integration of Africa Board into the JSE's main board. Collaboration with BRICS exchanges for cross-listed derivatives. JSE ensures Safecom Clearing House complies with CPSS ISCO standards. 2014 JSE launches Collocation Center for faster market access. Let me know if you need any refinements. Rocket emoji, next. Page 19, 2 facts and figures about stock exchanges in South Africa. JSE, June 2018, 376 listed companies, 48 small/medium capitalization companies, 2 Black Economic Empowerment, BEE companies, 76 foreign companies. Market capitalization are 14.4 trillion. Other South African stock exchanges, A2X, 8 primary and 8 secondary listings, market cap, are 209.3 billion. 4Ax, 5 listed companies, market cap, are 5.7 billion. ZARX, 4 listed companies, market cap, are 2.8 billion. EASE, 1 listed company, market cap, are 498.2 million. JSE Market Indices, FTSE/JSE All Share Index, ALSI, Primary Market Performance Indicator. FTSE/JSE Top 40 Index, measures value changes of the 40 largest companies. FTSE/JSE Industrial 25 and FTSE/JSE Financial 15, sectoral indices. Indices serve as economic indicators and bases for exchange-traded products, ETFs. JSE Commodity Derivatives Market, only functioning commodity derivatives market in Africa. Origins in agricultural derivatives, price transparency and risk management. Future plans to expand to East Africa. JSE and African exchanges, largest and most diversified exchange in Africa, accounts for 70% of Africa's market capitalization. One of 4 African members of the World Federation of Exchanges, WFE, with Egypt, Morocco, Mauritius 1923 becoming a listed company. Benefits of listing: access to capital, raise public funds for expansion and acquisitions. Investment opportunity: shareholders can earn profits via share price appreciation and dividends. Enhanced reputation and public profile leads to more business opportunities. Higher regulatory requirements, increased scrutiny and compliance costs. Liquidity and price discovery: shares can be easily traded, market determines share value. Broad-based B, facilitates shareholding via B schemes. Increased investor base, attracts pension funds, asset managers, and institutional investors. Index inclusion, if eligible, increases trading liquidity. Regulatory requirements, Financial Markets Act, FMA. All listed companies must comply with exchange listings requirements. More onerous disclosure requirements than Companies Act. High regulatory compliance costs. FMA Section 11(1), minimum listing requirements for all licensed exchanges. A. Rules for listing removal or suspension of securities. B. Compliance requirements for issuers and agents. C. Standards of conduct for issuers and company officers. D. Disclosure and corporate governance standards. E. Necessary details of listed securities. F. Disciplinary procedures for violations. G. Penalties for non-compliance purpose of listings requirements. Ensure full and accurate disclosure for informed investment decisions. Not a guarantee of profitability or share value. Regulators cannot reject listings based on commercial viability. Pre-listing statements, mandatory in some cases, outlining company details and prospects. If it includes a public offer, must comply with S-100 of the Companies Act, 2008. Next. Page 19.3. The South African Regulatory Framework, the FSRA and FMA regulatory challenges. Securities regulation requires continuous review to remain effective. The global financial crisis prompted reforms to South Africa's financial regulatory system. Financial Sector Regulation Act, FSRA, effective 1 April 2018, implements G20 financial regulatory reforms. Introduces the Twin Peaks regulatory model. 1. Prudential Authority, PA, ensures financial institution safety and soundness. 2. Financial Sector Conduct Authority, FSCA, regulates business conduct and customer treatment. Goals of the Twin Peaks model, as per 2011 National Treasury Policy, eliminates fragmented regulation, prevents regulatory arbitrage, closes regulatory gaps, combats financial crime, mitigates financial instability risks, enhances consumer protection. Financial Markets Act, FMA, effective 3 June 2013, the FMA is a financial sector law under the FSRA. All market infrastructures, exchanges, clearing houses, etc., must be licensed under the FMA. In case of conflict between FSRA and FMA, the FSRA prevails. The FSCA enforces and supervises FMA compliance. 19.3.1 Overview of the Financial Markets Act. Systemic Risk Regulation. Systemic risk equals the risk of failure or disruption of the financial system. The FSCA must report systemic risk concerns to Minister of Finance, Governor of the South African Reserve Bank, SARB. Reserve Bank's role, first time the Governor of SARB, is included in market regulation. SARB oversees trade repositories and clearing houses. 2 key systemic risk provisions. 1. FSCA must report systemic risk indicators. 2. Market infrastructures must avoid activities that cause systemic risk. Twin Peaks approach in the FMA. Prudential Regulation PA regulates capital markets participants, for example, banks, insurers. Covers macroprudential, microprudential and financial stability issues. Market Conduct Regulation, FSCA, regulates financial services market conduct, banking, insurance, advisory, etc. 19.3. 2 Objects of the Financial Markets Act, Section 2 FMA. Objectives. A. Ensure fair, efficient and transparent financial markets. B. Increase confidence in markets by requiring fair and efficient securities services. Supporting financial market stability. C. Protect investors, clients and regulated entities. D. Reduce systemic risk. E. Enhance international and domestic competitiveness of SA financial markets. Regulatory focus ensures investor protection while fostering international competitiveness. Strengthens confidence in SA securities markets through supervision and global standards alignment. Next. Page 19.3.3 Application of the Financial Markets Act, FMA. Scope of regulation. The FMA regulates financial market participants from a service provider supply-side perspective. It governs both the supply of services and market infrastructure that constitutes the financial market. Definition of a regulated person, broad scope to ensure full regulatory coverage, licensed central securities depositories, clearing houses, exchanges, trade repositories, authorized users, clearing members, nominees, participants, issuers in certain cases, other persons designated by the Minister. Definition of market infrastructure, Section 1 FMA, licensed central securities depository, licensed clearing house, licensed exchange, licensed trade repository. Regulatory requirements for market infrastructure must be licensed and comply with FMA obligations. Required to inform the registrar of any events that may pose systemic risk to financial markets. The term events is not defined in the FMA and must be inferred from the activities of regulated entities. Next. Page 19.3.4 Regulation of Trading in Securities. Scope of regulation. The FMA regulates all aspects of listed securities transactions, including initial listing, custody of securities, giving advice on buying/selling, trading in securities, clearing and settlement. Regulatory enforcement. Market infrastructures must adopt and enforce rules governing these matters. Exchanges must establish rules for admission of authorized users, members/stockbrokers. Regulation of authorized users' activities. Securities services must comply with the FMA and exchange rules under the supervision of exchanges and the FSCA. 19.3.4.1 Authorized users. Definition and role, gatekeepers between buyers/sellers of securities and exchanges. Must comply with exchange rules, covering operations, client relations, etc. Code of conduct prescribed by the FMA Registrar. Code of conduct, FMA prescribed, general duties of authorized users. Advice and disclosure obligations to clients. Record-keeping requirements. Regulation of inducements and advertisements. Client statements and related obligations. 19.3.4.2 Custody and administration of securities. Purpose. Investors avoid handling physical certificates of securities. Service providers manage custody and safekeeping of securities. Transfer arrangements upon disposal. Regulatory framework. Custody and administration. Service providers must be regulated. Ensures efficient completion of transactions. Buyers receive securities. Sellers receive payment. Central Securities Depository, CSD, a licensed market infrastructure providing a common custody platform. Participants equals entities providing general custody and administration services to market participants. Dematerialization of securities. Companies Act 2008 compliant, no more physical certificates, all securities are recorded electronically. Central registry maintained by licensed CSDs ensures reliable recording of securities issuance and transfers. Minimized fraud risk. South African equities market dematerialization process began March 2001, completed 2003. Only dematerialized securities can be used for transactions on the JSE. Licensed CSDs in South Africa. Strata, Granite. CSD participation requirements. Investors must open an uncertificated securities account with the CSD participant. Current CSD participants: Absa Bank Limited, First Rand Bank Limited, Nedbank Group Limited, Computershare, Société Générale Johannesburg, Standard Bank of South Africa Limited. Types of custody arrangements: broker custody model. Investors keep shares/cash with brokers. Brokers maintain accounts with CSD participants for custody purposes. Direct CSD participant model. investors appoint their own CSD participant to act on their behalf. Next. Page 19.3.4.3 Nominees. Definition and role. A nominee is a person/entity holding securities on behalf of the actual owner for convenience. Owners may prefer not to have securities registered in their own names. Nominees include executors of deceased estates, trustees of insolvent estates, other legally appointed disposers. Regulation under the FMA, approval process, if nominee represents an authorized user, exchange member, approval by exchange. If nominee represents a CSD participant, approval by CSD. If nominee is not approved by either, approval required from registrar. 19.3.4.4 Clearing and settling of transactions in listed securities. Definition and function. Clearing and settlement involves payment processing and transfer of securities from seller to buyer. Steps. 1. Determine exact quantity of securities and payment obligations. 2. Execute settlement, discharge transaction obligations. Clearing house, appointed by an exchange to handle clearing and settlement. Must be licensed under the FMA. If not performed in-house by an exchange, must be licensed separately. Licenses must be renewed annually by the registrar. Mergers and transfers. 2 or more clearing houses can merge or amalgamate. Assets/liabilities may be transferred to another clearing house with registrar approval. 19.3.4.5 Trade repositories. Definition and role. A trade repository maintains a central electronic database of transaction data, required to disclose all transactions related to unlisted securities, for example, derivatives trading. Regulatory objectives. Enhancing market transparency. Providing data for regulatory authorities for market surveillance. Financial stability policies. 19.3.4.6 Segregation of securities. International standards, based on International Organization of Securities Commissions, IOSCO, and Bank of International Settlements, BIS recommendations. Ensures securities regulation supports segregation of securities. FMA requirements. Authorized users must maintain separate securities accounts for their own securities. Client securities. Funds of clients must also be segregated. Investor protection. If an authorized user becomes insolvent, segregation ensures client funds and securities remain client property. Assets do not become part of the broker's insolvent estate. 19.3.5 Definitions in the Financial Markets Act, FMA. Key definitions. To ensure effective regulation, central securities depositories, CSDs, participants, clearing houses, trade repositories. Market abuse. Definition of securities services, covers buying and selling of securities, custody and administration, management of securities, clearing and settlement of transactions. Regulatory oversight. FMA ensures all financial market participants are regulated, including market infrastructures, issuers, authorized users, participants, employees and agents of regulated entities, clients. Definition of securities. Broad scope includes shares, stocks, depository receipts in public companies, derivative instruments, bonds, debentures, collective investment scheme participatory interests, index-based instruments. Exclusions. Money market instruments, except for custody and administration. Next. Page 19.3.6 Prohibitions in the Financial Markets Act, FMA. Licensing requirements. No person may operate as an exchange, CSD, clearing house or trade repository without an FMA license. Ensures only compliant entities operate as market infrastructures. Restrictions on authorized users and participants. Individuals/entities cannot act as authorized users or participants unless properly authorized. Authorized users may not conduct business with unapproved investment managers, regulated under FAI's Act. Buying and selling of securities. Listed securities. Only permitted if the person is an authorized user of the exchange, trading through an authorized user, a financial institution transacting with another financial institution. Corporate transactions that change beneficial ownership of listed securities outside an exchange must be reported to the registrar. Transactions through authorized users must be disclosed on the exchange trading system and cannot be executed off-market. Unlisted securities buying and selling are allowed only if they comply with Minister's regulations. Registrar's imposed conditions. Regulation of unlisted securities is aimed at controlling over-the-counter (OTC) derivatives, which contributed to the 2008 financial crisis. 19.3 Govern market infrastructures. Definition: S1 FMA. Market infrastructures include licensed CSDs, licensed clearing houses, licensed exchanges, licensed trade repositories. Duties under FMA SS 10, 30, 50 must adopt and enforce rules and listing requirements. Distinction between licensed duties of market infrastructures, securities services by authorized users and participants. Authorized users/participants must comply with market infrastructure rules. Securities services are subject to market infrastructure regulation and supervision. Obligations of exchanges. Listing requirements. Exchange must have rules for investigating and disciplining issuers, directors, officers, or employees who violate listing requirements. Penalties for non-compliance. Reprimands. Fines. Disqualification from director/officer roles. Compensation to affected persons. 19.3.8 Regulation of market infrastructures. Regulatory supervision, SS 10, 30, 50 FMA. FSCA directly supervises market infrastructures. If a market infrastructure fails in its duties, FSCA can assume responsibility. Requirements for market infrastructure leadership. A person cannot be appointed to a controlling body if they are disqualified from being a director under the Companies Act, 2008, were penalized for dishonesty in disciplinary proceedings, do not meet FSCA's fit and proper requirements, control and shareholding restrictions. FSCA approval required if acquiring more than 15% of shares in a market infrastructure. Purpose: ensures FSCA oversight over ownership structures, prevents systemic risks in SA's financial system and securities markets. Next page. 19.3.9 Regulation of market abuse. Importance of market abuse regulation. Financial crime and market abuse harm market integrity and efficiency. Public confidence in fair markets enhances liquidity and efficiency. FMA requires exchanges to have systems for transaction surveillance and supervision of authorized users to detect market abuse. Exchanges must report suspected market abuse to the Directorate of Market Abuse, DMA, under the FSCA. Forms of market abuse. 1. Market manipulation, SATFMA, includes false, deceptive, or manipulative trading practices, for example, artificial market prices. Prohibited conduct. Creating false/deceptive appearances of supply, demand, or trading activity. Artificially influencing the price of a listed security. 2. Insider trading, S77 FMA, inside information. Specific, non-public information that, if disclosed, would materially affect the price of a listed security. Prohibited conduct. Trading on inside information for personal or third-party gain. Advising others to trade based on inside information. Disclosing inside information to another person. 3. False and misleading statements, S81 FMA, prohibits false, misleading, or deceptive statements about past or future performance of listed securities. Financial health of a company, for example, inflated revenue/profit claims. Withholding price-sensitive information to prevent share price decline. _ Investigation and enforcement. Powers of the DMA and FSCA, under FMA and FSRA. Search and seizure of records. Interrogation and investigation of suspected market abuse. Identification of beneficial owners of securities held in nominee accounts. Full forensic investigations on alerts flagged on the JSE trading system. Global cooperation. FSCA has agreements with UK's FCA and US SEC to track cross-border insider trading. Example, if a South African trader uses a London broker for illegal trades, FSCA can request FCA intervention. Sanctions and penalties. FSCA actions. Recover profits gained or losses avoided. Impose fines up to 3x the amount of unlawful profit/loss avoided. Compensation claims for affected parties. Criminal liability. Fines and imprisonment. FSCA may prosecute if the state declines. Criminal prosecution is rare. Civil penalties, compensation and fines are preferred. Next page. Chapter 20, Business Enterprises and Human Rights. 20.1 Introduction. Corporations significantly impact economic and social life. Large multinational and domestic corporations hold immense power, influencing various sectors, for example, manufacturing, retail, mining, banking. There is growing concern about regulating corporate activities, especially those of multinational corporations, MNCs. The 2011 UN Guiding Principles on Business and Human Rights, 2011 guidelines, were developed by Professor John Ruggie to regulate corporate conduct. These guidelines are based on International Bill of Human Rights, International Labour Organization, ILO conventions. Companies must consider additional human rights standards when dealing with vulnerable groups, children, women, indigenous peoples, ethnic minorities, persons with disabilities. _ 20.2 The role of the state in remediation. Obligations of the state, 2011 guidelines. 1. Protect against human rights abuses by third parties, including business enterprises. 2. Implement policies, laws and adjudication to prevent, investigate, and punish corporate human rights violations. 3. Set clear expectations that corporations domiciled in their jurisdiction must respect human rights. 4. Strengthen legal frameworks to allow for corporate accountability, for example, requiring parent companies to report on global operations. _ 20.3 Human Rights and Business Enterprises. Corporate responsibility to respect human rights. Avoid infringing on human rights. Address human rights violations they are involved in. Minimum standard of human rights includes international law, for example, ILO Declaration on Fundamental Principles and Rights at Work. Additional standards for vulnerable groups, indigenous peoples, women, minorities, disabled persons, migrant workers. International humanitarian law in conflict zones. Applies to all businesses, regardless of size, sector, ownership, or structure. Businesses must establish human rights policies, due diligence and remediation processes. _ 20.4 The Bill of Rights and Corporations. Operational Principles for Businesses, 2011 Guidelines. 1. Human Rights Policy Statement. Approved at the senior level, publicly available and communicated to employees, business partners and stakeholders, integrated into operational policies and procedures. 2. Human Rights Due Diligence. Processes to identify, assess and mitigate human rights risks. Track responses and communicate steps taken. Recognize that human rights violations may result not only from direct activities, but also from business relationships. 3. Remediation of human rights violations. Businesses must provide or cooperate in remediation when responsible for human rights harm. Grievance mechanisms should be accessible, fair, and transparent. _ Operational level grievance mechanisms. Key principles. Stakeholder trust is essential for usage. Access barriers, language, cost, literacy, fear of retaliation, must be addressed. Clear procedures and timelines should be established. Transparency and confidentiality must be balanced. Addressing power imbalances between corporations and affected stakeholders. Regular analysis of grievance patterns to prevent future harm. Stakeholder engagement ensures legitimacy and effectiveness. Independent adjudication when necessary, ensuring corporations do not unilaterally decide outcomes. Conclusion. States and corporations share responsibility in protecting human rights. Businesses must actively prevent and address human rights abuses within their operations. Effective grievance mechanisms ensure access to justice and maintain corporate accountability. Next page. Chapter 20, Human Rights and Business Enterprises. 20.1 Introduction. Corporations significantly impact citizens' daily lives, from food choices to financial stability. Justice Mmaezeli Madlanga highlighted the immense influence of multinational and domestic corporations in industries like manufacturing, retail, mining, and banking. Increased concerns over corporate regulation, particularly regarding human rights abuses. 2011 UN Guiding Principles on Business and Human Rights, 2011 Guidelines, developed by John Ruggie to provide a framework for corporate human rights responsibilities. Core principles. Based on the International Bill of Human Rights and ILO conventions, companies must consider additional human rights standards for vulnerable groups, for example, children, women, indigenous peoples, persons with disabilities. Obligations under the 2011 guidelines. 1. State responsibility. States must protect against human rights abuses by businesses through policies, legislation, regulation, and adjudication. States are not directly responsible for private actors' abuses, but may be liable for failure to prevent them. 2. Expectations of business enterprises. Businesses must respect human rights in all operations, including supply chains and subsidiaries. Measures include reporting on global operations and enforcing criminal liability for corporate misconduct. 3. Corporate responsibility. Businesses should prevent human rights infringements and address abuses they cause or contribute to. Must uphold internationally recognized human rights, especially under ILO's Declaration on Fundamental Principles and Rights at Work. Special obligations to marginalized groups, and in armed conflict situations. 4. Applicability of corporate responsibility. Applies to all business enterprises, regardless of size, sector, or structure. Companies must adopt policies and processes that identify, mitigate, and address human rights risks. Operational principles for business enterprises. 1. Policy commitment. Approved at the senior level. Sets clear human rights expectations for personnel, business partners, and stakeholders. Publicly available and integrated into company policies and procedures. 2. Human rights due diligence. Businesses must assess, prevent, mitigate, and track human rights impacts. Impacts may arise from direct activities or business relationships. 3. Remediation responsibilities. Companies must provide or cooperate in remediation when they cause or contribute to human rights abuses. Effective grievance mechanisms should be trusted by stakeholders, accessible without language, literacy, cost, or location barriers, transparent regarding procedures and expected timeframes, fair by addressing power imbalances between businesses and affected stakeholders, regularly analyzed to identify patterns of abuse and inform policy changes, independent, ensuring businesses do not adjudicate complaints against themselves. 20.2 The role of the state in remediation. States must ensure effective remedies for human rights abuses by businesses through judicial, administrative, and legislative means. Legal barriers preventing prosecution of business-related abuses must be removed. States must ensure accountability in domestic civil and criminal law for corporate misconduct. Non-judicial mechanisms, for example, mediation, arbitration, can enhance access to remedies. Case study, Alien Tort Statute, Royal Dutch Shell and the Ogoni people. Shell's role in Nigeria, alleged complicity in military violence against the Ogoni people opposing oil production. Legal action in the U.S. Case filed under the Alien Tort Statute, 1789, allowing non-U.S. citizens to sue for human rights violations. Outcome, $15.5 million settlement in favor of the Ogoni people. Application of the UN guidelines could have provided preventative measures and corporate accountability frameworks, reinforced corporate responsibility, and state duty to protect against human rights abuses. 20.3 Human Rights and Business Enterprises. Traditional corporate model, Milton Friedman. Businesses exist solely to maximize shareholder profits within legal frameworks. Counterargument. Corporations impact fundamental rights such as access to food, water, and healthcare. They should contribute to human rights protection, not just profit-making. Case study, HIV/AIDS and pharmaceutical patents. Issue. Pharmaceutical patents granted companies the right to charge high prices for life-saving antiretroviral drugs, making them inaccessible in developing countries. Solution. The TRIPS Agreement, trade-related aspects of intellectual property rights, enabled access to essential medicines, knowledge transfer and capacity building for local drug production. Implications for COVID-19. Vaccine-producing corporations faced ethical and legal questions about pricing and global accessibility, balancing shareholder profits versus global public health obligations. Potential solutions. Waiving patent rights to allow generic production. Government intervention to ensure equitable distribution. Public-private partnerships for fair pricing. 20.4 The Bill of Rights and Corporations. Key question. Do corporations have obligations beyond profit maximization? Historical approach. Interim Constitution, 1993, initially excluded private parties from direct human rights obligations. Dissenting view, Madala J. Apartheid-era inequalities required the Constitution to apply at all levels, including private relations. Current approach under the 1996 Constitution. Section 8.2. The Bill of Rights applies to private parties, including corporations, where relevant. Daniels v. Scribant, Constitutional Court decision. Factors determining corporate obligations. Nature and history of the right. Risk of private violations. Would excluding private parties undermine the right? Private actors may bear positive obligations to uphold human rights. Corporate human rights obligations under the Bill of Rights. Equality, S9. Corporations must ensure non-discriminatory practices in employment and customer interactions. Dignity, S10. Employees and customers must be treated with respect and fairness. Privacy, S14. Safeguarding personal data and respecting employee confidentiality. Environmental protection, S24. Businesses must prevent environmental harm from their operations. Economic regulations under S39(2). Courts must interpret laws in line with human rights principles. Competition Act example. Price regulation of essential drugs by pharmaceutical firms aligns with the right to health care. Discussion questions. 1. Should profit maximization be the primary goal of corporations, or should they also consider societal obligations? 2. Are human rights duties an unfair burden on private businesses, or are they necessary for social justice? 3. Should the state alone regulate corporate human rights practices, or do corporations share responsibility? Key takeaways. Businesses impact human rights and must adopt policies to prevent and address abuses. 2011 guidelines impose obligations on both states and corporations. The state must provide legal and non-legal remedies for corporate human rights abuses. Corporate responsibility extends beyond shareholders. They may bear positive human rights obligations. South African Constitution, S82, explicitly binds corporations to certain human rights duties.